Welcome, everyone. Today will be the fifth and final installment of the lecture series on civil liberties. It's, if you missed the first four, go back and take a look at those. We've dealt with, freedom of religion, speech, press, all of these things. Today we're going to talk about due process and the rights of the accused. And if you think about the scope of the Bill of Rights, today, we're talking about due process and the rights of the accused. We're talking about amendments 4, 5, 6, 7, and 8. That's a huge chunk of the Bill of Rights. So if you're looking at what the intention of the Founding Fathers were when it came to civil liberties, obviously, sheer numbers, they were really concerned about government overstepping their bounds in a sense of accusing people of crimes or, putting people in prison, those things where we deal with this criminal activity. So very, very important to the Founding Fathers, given the sheer number of amendments that deal with that. We're not going to talk about 8. 8 was cruel and unusual punishment. We could have a great lecture on that, but you can figure that one out. 7 deals with civil cases. 6 we already dealt with in the Gideon versus Wainwright case, the right to an attorney. We'll talk about the 4th and the 5th mostly today, and I want to start with the 4th because the 4th generates probably more questions than any other issue when we're talking about in class, because it deals with what can the police do, what can the government do, what can the state do if you are accused of a crime or whatever. So just the text of it, the right of the people to be secure in their person, houses, papers, and effects. That includes a lot. Against unreasonable searches and seizures, and they have to have a warrant, but upon probable cause, supported by oath and affirmation, describing those things. So when you look at the 4th Amendment, there are 3 things that stick out glaringly to me that I want to point out. First of all, this fundamental right that we have to be secure in our person, effects, places, our house, those types of things. We have that liberty, that freedom, the knowledge that we are secure in our stuff. So that's going to become a big thing here. Against unreasonable searches and seizures. So the question always comes up is, well, who gets to determine if it's reasonable or unreasonable? And I think by now you know the answer to that question. It is, of course, the courts. They always get to decide whether or not, after the fact, it was reasonable or unreasonable. And the third thing is that if they're going to search your stuff, they have to have probable cause. They can't just say, I don't like him, I don't like the way he looks, I don't like the way he dresses, he's kind of shifty, I'm just going to search his stuff. No, they cannot do that. They have to have some reason to search you or your house or your effects. So they must have probable cause. So looking at that, first case that I want to take a look at with this is Matt versus Ohio. This goes back to the late 1950s, early 1960s. In Ohio, this was a case where there was a fugitive on the run and, criminal, the police were looking for him. His girlfriend, of course, had a house in Cleveland, and they decided that she was probably harboring a fugitive. So they wanted to go check it out and make sure that this guy wasn't hiding in her house. So they come in, they knock on the door, and they say, we're going to come in, let us in, we're going to take a look for this guy, we think you're harboring a fugitive. And she's like, no, you cannot come in without a warrant. And they're like, okay, so they leave and they watch the house for like 2 or 3 hours, no activity. So they show back up, knock on the door, and they wave a piece of paper in the air. And then they kind of force their way in. So here's this weird piece of paper that they're flying. And so they search the house. Of course, he's not there. But what they find in her basement in a small trunk is, believe it or not, pornography. And at the time, in 1961, in Ohio, it was illegal to possess things of illicit material. So anything to do with pornography was illegal. So they find this, and boom, they've got something. They arrest her on it, and this goes to court, and goes all the way up to the Supreme Court. And the Supreme Court ruled basically that said, well, first of all, can you produce the warrant that they were waving in the air? And they couldn't. So we now know, hindsight's 2020. Looking back, there was no warrant. They were just making it up. So the justices were looking at this, and 2 things kind of with this case that piqued their interest. One was, if they're looking for a fugitive, could he theoretically be hiding in a small trunk? And the answer was no. So did they have a right to look there if they're looking for a fugitive? Remember the 4th Amendment describing the things to be searched. A human couldn't have hidden in that trunk, so they shouldn't have been in there in the first place. The second thing, if they did not have a warrant, are they then violating her 4th Amendment rights to, but upon probable cause and a search warrant issued? And the Supreme Court said, no, you have to have it. And so they threw this out. And what they came up with in this case, very important term to know, the exclusionary rule. So what that means is if the police are searching your house, or something to where they have to have a warrant or whatever, and if they find evidence that they're not warranted to find. In other words, if they look somewhere where the warrant says you can't look in an outbuilding or whatever, if they do that, then that's wrong, and that's evidence obtained illegally. So what they came up with this exclusionary rule is, if they find something that is illegal, but it wasn't what they were searching for, they cannot use it in court. So they can't just come up with something and using it in court. Fruit from a poisonous tree is still poisonous. So this becomes very important. So when a search warrant is issued today, they will specifically say, we're looking for this, this, and this, and these are the places that we can look. Because if they don't, the chance that the court could throw it out, because they would be violating the exclusionary rule. Now, one question that comes up, again, nothing is absolute in this. What happens if they find something that you're not hiding? And the term we use here is in plain view. So if they're going to search for example, in this case, if they were to walk in and searching for this guy, and on the coffee table out in the open in the living room was a big pile of cocaine, right? Illegal to possess cocaine. That's in plain view. They didn't have to search for that. It was out in the open. So they could have arrested her for that. But the fact that they had to look somewhere where a human couldn't reasonably be hiding, that doesn't count. So the in plain view doctrine doesn't apply to this. The other exception would be, especially in a home, would be this imminent danger thing. If police are driving by and they hear, somebody yell help or screaming bloody murder, that's, somebody's obviously, there's imminent danger. They can go in the house without a warrant. Also, if they witness a crime being committed, or obviously, the big question always comes in high schools is like, well, what if we're having a party in our house? Can they come in? If they look through the window, which by the way they can, if they're on the street, you have no reasonable expectation of privacy if your drapes are open. So if your drapes are open, cops on the street, they can look in your window. That is not illegal. And they see you can, somebody that's obviously underage consuming alcohol, they just witnessed a crime. So they can enter the house without a warrant. So those are things that always come, and there are so many examples of things. Yes, they can do it. No, they can't do it. And without having a classroom in front of me, we can't really get those questions. So if you have a question about something with the exclusionary rule, shoot me an email. Give me a comment. We'll discuss them from there. Now, speaking of high school kids and high schools in general, another case, 1985, and this is when I was in high school, so I remember this case when it happened. New Jersey versus TLO. This is a case where there were a couple of high school girls in New Jersey. And by the way, TLO is the initials of the girl that was part of this case. Because she was a minor at the time, they didn't use her full name. So that's what TLO is. So it's in New Jersey, and there were a couple of girls in the bathroom smoking. And you can see the smoke coming out of the bathroom stall there. So a teacher walks in, you're busted. One of the girls admits to smoking, and the other girl, TLO, said, I was not smoking. So they take the two girls to the principal's office, and the principal, takes their purse and their bags and searches their bags. In her bag, in TLO's bag, they find, rolling papers, they find a wad of cash, they find a list of people that owes her money. So obviously, she's dealing, right? She's dealing probably marijuana because of the rolling papers. So, they call the police, they take them downtown, and she's arrested. And at the trial, of course, she's found guilty. Well, on appeal to the Supreme Court, her attorney says, that was an unreasonable search and seizure because they didn't have a warrant to check her purse. And the Supreme Court basically, and you know where this is headed, since it is a school, the rules are different. In parentis loci, what we talk about, this idea that, in place of your parents, teachers and administrators have a lot of leeway given the fact that we deal with children in a place where your parents are not there. So the court ruled, no, that's reasonable. They didn't need necessarily probable cause. All they needed to search her bag was a reasonable suspicion. So reasonable suspicion applies in schools, but in your house, they have to have probable cause and they have to get a warrant. So in between those two things, your house and school would be your car. So what do they have to search your car? And, the courts, it depends on the case. Cases will continue to come up. Is it reasonable? Is it not reasonable? Can they search? Can they not without a warrant? Bottom line is they do not need a warrant to search your car, but they do need probable cause. So if you get pulled over and they say, why I pulled you over? First of all, never answer that question, right? If the police say, do you know why I pulled you over? they're wanting you to admit to something. I probably shouldn't say this on YouTube, but no, I mean, if you're not doing anything wrong, no, just say no. I have no idea. I was abiding by the law. I have no idea. If they say, well, you were speeding, then that's fine. And if you were speeding, take your medicine, sign the ticket, pay your fine. You broke the law. But if you weren't speeding, or if they say, I clocked you at 40 and a 30, I want to look in your trunk. Like that's kind of cross the line. Why would they need to look in your trunk just for a speeding violation? So, there are things that you can do, you can say no to, but if they have problem, if they say, I smell marijuana, right? And by the way, police are trained for that smell, as are teachers, as are a lot of people. We recognize that smell. If they smell it, they're going to want to search your car. So if you're guilty, then you're guilty. All right, go pay your fine. Do whatever you need to do. But if you're not, you need to know your rights. They will, however, if they smell it, they can search your car, and they do not need a warrant. So they can look in your glove box, they can look in your trunk, they can look in various places, as long as they have probable cause to do that. Now, if you don't think they do, that's your turn at court to say, I didn't think they had probable cause. They need to explain, and they'll put the policeman on the stand. What was your probable cause to search the car? Lawyers are very good. Attorneys are very smart. So get a good attorney if you think that it was unreasonable. And those are the rights that you have. But in schools, a little bit different. Administration, police can search your stuff. They can search your car in the parking lot. They can bring the drug dogs in. None of that is a violation of your Fourth Amendment rights. So schools are a little bit different. Now, what about, and here we're going to get into a couple of cases dealing with abortion. And College Board, Roe v. Wade obviously is the big abortion case, which we'll talk about here in a second. But the first case kind of set the precedent for Roe versus Wade was Griswold versus Connecticut. This goes back to 1965. And in the state of Connecticut, believe it or not, in the 1960s, birth control was illegal. There was a huge build up to this. Pharmaceutical companies, and it's a small businesses. There's a whole backstory in this which we don't have time to go into, but it's awesome if you guys want to do the research on this. Anyway, so in Connecticut, birth control is illegal. So a woman is in possession of birth control. She is arrested, and she appeals, saying, "Hey, what does the government have? Why can't they look and see what I'm putting into my own body?" So here we have this idea of a right to privacy. Now, does the Fourth Amendment apply? But upon probable cause, you are, in that beginning sentence, you be secure in your person, places, and effects. Does the Fourth Amendment apply to birth control, to pregnancy? So that was this case before the court, and the Supreme Court, of course, ruled on the side of Griswold against the law in Connecticut, and they basically said, yeah, there is this right of privacy that we have inherently based on the first, third, fourth, fifth, amendments dealing with all of these issues, and of course the 14th due process that incorporated it into the states, which basically is protected by the Ninth Amendment. Remember, the Ninth Amendment was, just because it's not listed here doesn't mean you don't have that right. So the court did rule that, one of your Ninth Amendment rights, even though it's not specifically listed, is the right to privacy. So birth control being a private matter, the court ruled you have the right to take birth control. So that law was overturned. That then, of course, is going to lead to the big one that we talk about, and this one is required by College Board, and that is Roe versus Wade, 1973. And we see a picture of Roe and her attorney in front of the Supreme Court. And this case, kind of carried on the Griswold thing. Do you have, an inherent right to privacy? And this went all the way to the Supreme Court. And in a 7-2 decision, the court did side with the right to privacy. So they looked at, having an abortion is something that the government, you have the right to be secure in your person, place, and effects. Right to privacy. The government should not step into that arena because it is a decision that is made by, the woman and, of course, the husband or the man who, is the other part of that. But that is a decision there. So, because of the due process clause in the 14th Amendment, this right of privacy does also apply to abortion. Now, there have been several court cases since then dealing with abortion. And essentially, bottom line, just, the generic things that go on with abortion in the first trimester, you can get an abortion, no questions asked. In the second trimester, they can put, some limitations as far as, age and, parental consent if you're under the age of 16, those things. In the third trimester, we've had several cases recently. And by the way, the court is cracking away at Roe v. Wade. So if you're either pro-life or pro-choice, a lot of cases going on right now. There's one currently before the Supreme Court right now But basically, they can, put limitations on in the third trimester, like, health of the mother, life of the child, life of the mother, those types of things. So it just, the I guess the further along you are in your pregnancy, the more laws that they can pass restricting your right to an abortion. And it's an ongoing thing. They keep bringing these cases up, one thing or the other. One thing I will caution you, though, as far as my students go, when you use the terminology politically, because we talk a lot about politics, if somebody says pro-life, that means that they're against abortion. It means that they think that the child has a right to life and that you cannot terminate that life. And a lot of times it is, it's murder. It's murdering a child. So that's the pro-life stance generically. The pro-choice, and this is where we get into the politics of it. If you hear somebody say that people are pro-abortion, I have a problem with that phrase. I don't think anybody's pro-abortion. There are people that are pro-choice. I don't think anybody inherently wants to say, hey, what are you doing this weekend? I don't have any plans. Well, let's go get an abortion. It's something we can do. Nobody says that. So I don't think people are pro-abortion as much as they are pro-choice. So the argument then becomes pro-life versus pro-choice. And, take your side, and that's obviously up to you. But when we talk about politics, especially in an upcoming presidential election, anytime there are people running for the House and the Senate, the pro-abortion comment is usually kind of reserved for people outside of politics that really don't have an understanding of what's going on. But you are absolutely free to join one of those sides, and that is absolutely your call. So that's Fourth Amendment. So any question about Fourth Amendment, send them my way. The Fifth Amendment is another one that we're going to look at here, and there's so much in the Fifth Amendment. The Fifth Amendment lists several things that you have the right to, but I think the one that's most famous, of course, anytime you watch a movie or TV and somebody is at trial and they say, I plead the Fifth. Well, what does pleading the Fifth mean? Well, basically in the Fifth Amendment, it basically says you don't have to testify against yourself. So if you are the one on trial, you do not have to take the stand. You do not have to be forced to answer questions if you don't want to. You have that right in the Fifth Amendment. However, there are exceptions. Obviously, if you're the defendant, this doesn't apply to witnesses, but if you're the defendant and you plead the Fifth, that means you don't have to get up on the stand and answer questions. However, if you want to testify on your behalf, in other words, you say, I want to take the stand because I'm innocent and I want to get the truth out there. If you do that, you forfeit your Fifth Amendment rights. So you can't take the stand and say, as questioning gets going and all of a sudden you become uncomfortable, sorry, you waived your rights. And so as a defendant, you have to answer questions. For example, what if it's an embarrassing question you don't want to answer? Sorry, you take the stand, you have to answer that. Also, you cannot invoke the Fifth to avoid incriminating someone else. So even if you are the defendant, if they have questions about, an accomplice or witness, you do have to answer those questions because those aren't questions about your role. That's questions about somebody else's role, and the Fifth Amendment doesn't apply to you because it's not you that's being questioned about. So a lot of things, in the court with the Fifth Amendment that we look at, as far as you speaking out. Now, one thing, this is a leftover from the law class that I used to teach, and I really miss teaching law. One of the things that we always talked about in my law class is entrapment. What is entrapment? Well, entrapment basically is if the state somehow, tricks you or convinces you to break the law. And we hear a lot about this, and of course, all the TV shows. It's always, it's either drug use or prostitution, something like that. So if, an undercover officer posing as a prostitute comes up and says, hey, how about, sex for, $100? And you say, well, okay. Well, that's on them. I mean, if it's an undercover police officer, they can't do that. They can't say, hey, here's a crime. Do you want to break the law and commit this crime? That's entrapment. They can't do that. Likewise with drugs. They can't say, hey, I have some heroin, I'll sell it to you for $20. Well, basically what they're doing is they're telling you to break the law. That's entrapment. They can't do that. However, if it's a private citizen that says, hey, I have, heroin I want to sell you, and you get busted for that, if it's a private citizen doing it, that's not entrapment. It has to be the state, the police, those types of things. So entrapment's kind of fun, usually overplayed most of the time in TV shows and movies because policemen know that. Undercover officers know the law dealing with entrapment, so they just don't do it. So it's kind of, but it's a great conversation, one that I like. Now, Fifth Amendment right, not, incriminating yourself. Probably the most famous case that everybody knows about is Miranda versus Arizona, and that is the 1960s. And basically what happens is Miranda is arrested for suspicion of rape and kidnapping. A young woman was raped and kidnapped, or kidnapped and raped, and basically gave a description to her brother about the person and the car they were driving. So the brother sees the car, calls the cops, and of course the cops now have probable cause, and that would be probable cause, pull him over and question him. And what they do is they take him downtown, put him in a lineup, and coerce a confession out of him. They basically say, you've been identified by the victim. We know it was you, so go ahead and confess. And so he did, and he wrote it down. Yeah, I did it. The problem was he was not aware that he didn't have to do that. And so this case goes all the way to the Supreme Court, and basically his attorney made the argument that since my client was not aware that he did not have to write that or to confess that, that was a violation of his Fifth Amendment right to be free from self-incrimination. And the court agreed with him. So in the Supreme Court, it said, yes, you have to, since he didn't know the right, just because you don't know that you have a right doesn't mean you don't have it. Now, that's kind of the other part of that argument. So he goes, I didn't know I didn't have to. Court said, you're absolutely right. So now the police have to read you your Miranda rights. And we get that from this case. You have the right to remain silent. Anything you say will be used against you in a court of law. You have the right to an attorney. That's that Sixth Amendment right. He also didn't know he didn't know he could have an attorney present. So that was part of that case as well. And so they read you these Miranda rights anytime you're being placed under arrest. Now, if you're just being questioned, they don't have to read you your Miranda rights. They read your Miranda rights if you're being placed under arrest and they're questioning you about the case. So, if a policeman stops and wants to just ask you questions, the Miranda rights don't apply. Just answer the question or refuse, doesn't matter, either way. But they do not have to read your rights unless you're being placed under arrest. So the irony of this case was, years later, of course, and Miranda was in and out of jail, and he had been in jail for violating his parole for another crime. So he got out of jail from there, went to a bar, and a bar fight broke out. And he was stabbed, and as a result of his wounds, he died. So he died in a bar fight in the early 1970s. And the person that killed him, when they were arrested, were read their Miranda rights. You have the right to remain silent because of that guy you just killed right there. So that's just it's a weird ending to a weird case. But they do have to read you those rights. And what advice that I would always give people, they say, well, but if you're on trial and you say, well, I plead the Fifth, doesn't that mean you're guilty? And the answer is absolutely not. In fact, if you are ever accused of a serious crime and you're innocent, always plead the Fifth. Always plead the Fifth. It does not mean you're guilty. It just means that that lawyers will try to put you in a situation that maybe they'll twist your words. They'll try to, make it to look like maybe you don't know what you're talking about, leave doubt in the jury's mind or whatever. So I would, if you're accused of being accused of a serious crime and you're innocent, always plead the Fifth. Always let your attorneys do that. Don't get up there and let people twist what you say. So, but if you're guilty, you're guilty. Pay your fine. Whatever it is. Don't play nonsense with the courts. That's not what they're for. These protections are not for you to get out of a crime. They're to protect you in case you're accused falsely of a crime. So always keep that in mind. Now, another part of the Fifth Amendment is double jeopardy. And double jeopardy, obviously, it is the fact that you cannot be tried for the same crime twice. And the movie, of course, it came out. It was in the 90s, wasn't it? Tommy Lee Jones and Ashley Judd. And the thing about the movie, and I always tell my classes this, the movie gets it wrong on so many levels. Basically, her husband basically frames her for his death, but he didn't die. But he makes it look like she did it, so she goes to prison. Now that she's been convicted of murder, she gets out of prison, and he's alive. So she thinks, and the premise of the movie is, now I can kill him because I've already been convicted of murder, so they can't try me twice. Well, that's nonsense because the first crime never happened. So it's a new crime, so you can't know. So the movie bothers me, but it's got some good acting in it. So give it a shot. I don't know. But anyway, so but if it is a situation where you are convicted of a crime, that's it. Conviction is one thing. It's when you're found not guilty that the Fifth Amendment kind of comes into play here. So if you're accused of, let's say, murder. Murder is always a good one to use. And, goes to trial, and a jury of your peers finds you not guilty of murder. After the trial, then, if they find more evidence and that does prove that you committed that murder, they cannot take that new evidence and bring you back to trial. They just can't. That's kind of what that's for. I think the classic case of O.J. Simpson. The fact that he was found not guilty of murder, and everybody talks about, oh, he was going to write that book. He was never going to write the book. Nobody's going to publish that book. But even if they did find evidence, they could not try him again because he's already been found not guilty. Now, obviously, there are some exceptions to this. What if you commit a crime that is both a state crime and a federal crime? Probably the best example here is Timothy McVeigh, the Oklahoma City bombing, 95, 96. And basically, he blew up a federal building, which is a federal crime, and in the process committed murder, which is a state crime. So there were civilians in the building. So it's the state crime of murder, federal crime, federal murder because there's also federal employees. So an exception here would be if he was found guilty at the state level, then he goes to prison. Nothing else is needed here. But if he's found not guilty at the state level, for example, Timothy McVeigh in Oklahoma, if he would have been found not guilty, the federal government still could have tried him for murder because it's a two-part crime, state and federal. So double jeopardy doesn't apply there because that's basically looked at as two separate crimes, even though it's one event, one state, one federal. So that would be an exception. The other exception is civil and criminal. We talk about in the Seventh Amendment, deals with, if you are accused of a civil, wrongdoing, different than a criminal offense. So we go back to the O.J. Simpson one. The criminal charge was murder. He was found not guilty of murder, by a jury of his peers, so they can't try him again. But the family of the victim, of his former wife, the idea that her family accused him of wrongful death and sued him in court. Now, there's between criminal and civil. I would love to get into that a little bit deeper, but in a criminal case, they had to be positive that he was guilty beyond the shadow of a doubt. There can be absolutely no doubt whatsoever that O.J. was guilty of murder. There was doubt because of the glove and all that stuff. That if the glove doesn't fit, you must acquit. John Cochran. But in a civil case, it's just a preponderance of the evidence, which means 50% or more. If you're pretty sure 51%, unsure 49%, boom, then you can say, yeah, he's guilty of a civil offense. In a civil crime, there's no jail time. It's not a crime, but it's a lawsuit, so you would have to pay damages. So he was found guilty in civil court of the wrongful death of the two people, and so he was forced to pay money in damages. So that's not double jeopardy. It's two different things. The other thing would be if there's a hung jury. So if you go through the trial and the defense rests, prosecution rests, and it goes to the jury deliberations, and they can't come up with this is something that we just don't know. We can't come up with guilty or not guilty, and that's what they call a hung jury. If the judge, and there's a certain amount of time a judge will give a jury to figure this out. If they can't come to a decision, that is known as a hung jury, they disband that jury and bring in 12 new people. That's a new jury, and you also, then another trial ensues. That's not double jeopardy either. And remember, because you were not found not guilty, it was just a hung jury, so it doesn't apply to double jeopardy. And then likewise, when you appeal something, you've been found guilty already, so double jeopardy, they can't come back and try you again. Why would they? You've already been found guilty. The appeals process is when you say, hey, I think the state did something wrong, or I think it was wrongful conviction. Then you might get a new trial, or a new hearing at the appellate level. That's not double jeopardy either, because you've already been found guilty. The appeals process is not a new trial. So now, what about a plea bargain? And this is kind of fun because because this is when last time I was called for jury duty. Went in, you're sitting in the courthouse and you wait. Well, I'm thinking to myself, and I was a lot younger then. What's taking them so long? I mean, why am I sitting here, trying to get interviewed for jury duty and nothing's happening? Well, what was going on behind the scenes was the attorneys were trying to get, a deal made that if the accused pled guilty, so I did it. If I plead guilty and save the time of the trial, and all that stuff, will you reduce the sentence? And that's what was going on, when I was there. That's called a plea bargain. So somebody that is, saying, all right, I'll plead guilty if I get this in exchange, that's guilty, right? So you've pled guilty. So again, double jeopardy doesn't apply to that because double jeopardy only applies if you've been found innocent. So those are some things. So hopefully, Fourth Amendment, Fifth Amendment, civil liberties in general. Hopefully, you've learned something about this. Bottom line, it will always be the ultimate decision will be made by the courts. But I want to leave you with this on civil liberties. Some famous quotes, a couple of them. One, of course, is from Ben Franklin. One of my favorites. He who is willing to give up essential liberty to obtain a little temporary safety deserve neither liberty nor safety. So civil liberties and freedoms were so important to the founding fathers. If you are willing to give up your freedoms, you don't deserve them, right? And that was kind of the thing. That's how important these things are. So understand what your rights are, what the laws are, because you don't just want to surrender your liberty. And we countless historical examples of this. Another one is by Barry Goldwater, presidential candidate. I may disagree with what I'm sorry. Extremism in defense of liberty is no vice. And basically, what that means is if you have to become extreme to fight for your freedoms, then that's okay. According to Barry Goldwater, that was fine because that's how important they are. So if you feel your rights are being violated, I wouldn't say I don't think Barry Goldwater was condoning violence in the name of liberty, but extremism certainly doesn't mean you have to be violent with other people. But if you need to become extreme to protect your liberties, Barry Goldwater was all for that. And then, of course, the most famous one, of course, is Voltaire. I may disagree with what you say, but I will defend to the death your right to say it. And this goes, all those cases that we talked about with the Phelps clan and, Brandenburg and, the neo-Nazis in Illinois. All of those cases, as abhorrent, I think, as most people think those things are, they do have the right to say them. We also have the right to tune them out. So, but it's a fine line that we walk in America because we are the land of the free. But going back to that very, very first slide that I showed you, freedom versus order. How much freedom do we want versus how much order? And that is a balance that we try to strike all the time. And I think so far we've done a pretty good job with that. So hopefully you learned something about civil liberties. Again, if you have questions, shoot me an email, leave me some comments below the video, and I will do my best to get back to you. All right, see you guys next time.